Writ of Mandamus 224-2023.
I believe we are unmuted here in the Missoula County Courtroom 1. Julie, can you hear me?
I can, Your Honor.
Thank you. I will call our two cases on the 2:30 docket. This is Anderson versus Mineral County Attorney, DV 22-53, and Anderson et al. Versus Mineral County Sheriff, DV 22-54. We are here on a status conference. I don't know which attorney wishes to proceed first, Mr. Condon or Ms. Kilby. I do note that I did receive the notice of appearance, Mr. Lansidel, and see that you have come in on behalf of the Mineral County Sheriff.
Yes, Your Honor.
Thank you.
I'm happy to start, Judge.
You may proceed.
Thank you, Your Honor. Jordan Kilby for the record. So, the last time we were here, I had filed a status report, and the court had said that it had wanted to rely on those and, encouraged me to file another. I didn't in this case today because there hasn't been much progression. The only thing that I would change about the status report filed, it's docket number 74, is number 20. We have received the information from Lake County that the court reviewed and then sent to the county attorney's office. So that's been received. With respect to everything else, there's been no progress. To address the personnel files, Your Honor, the court had ordered the order of protection for that, the protective order, and allowed them to be transferred to us. Specifically, it said, that our secretaries could view them. But recently we learned that per Ms. Jackson, she didn't want them to leave the Mineral County Courthouse and that we had to come there to view them. And that's counter to what I interpreted your order to be. I don't think it makes financial sense for us to take 2 days and spend all that time down at the Mineral County Courthouse when there is a protective order. And so I believe that those should be sent to our office and that I'm asking the court to order that. I think the court has already ordered that. And then with respect to the last filing, which was docket 75, I don't really understand the representations that are made within, and that's something that maybe I need to meet with Mr. Congdon about. But it doesn't, a lot of the communications we get don't make a lot of sense to us. So the other thing that I wanted to let the court know, and I believe Mr. Jasper is on Zoom, is that unfortunately, our goal as petitioners in this was to help the county, the sheriff's office, and the county attorney's office comply with their statutory mandates and constitutional mandates of Brady and Giglio, as well as dealing with some of their hiring processes. We got to that point, Your Honor, because we had several clients and they've had to spend thousands of dollars litigating these issues, and we're trying to prevent that in the future. But unfortunately, it's come to our attention, and maybe we need to have a conference with the attorneys. I think that's maybe what Mr. Jasper was going to suggest to you with the court present, that there's been some retaliation, and it's kind of nastiness on the part of the county. There's been discussions with law enforcement about attempts to disbar Mr. Jasper, affect his firm, affect his family life, his house. He did the research into that and just learned of those things, and so he's here but not speaking today because he's pretty upset about it, Judge. And really, I think that it's totally unwarranted. We are really trying to work towards a common goal, and it doesn't need to turn into something that's been kind of very unprofessional. And there's serious concerns on Mr. Jasper's part. Additionally, and we just wanted to make the court aware of that, I think that, we are, again, just trying to do the right thing. And Mr. Jasper spent a lot of his time and money on this case. So I also think we need to update the court with respect to, and Mr. Lansadell can speak to this. We still haven't received any of the policy manuals. And the last time we were here, Judge, it was send the policy manual, send what you've worked on, and they'll review them. And actually, it came to the point where you were like, and Ms. Kilby can compare them, which again is going to be a waste of funds for the county, in my opinion, but I'm happy to do it if they're, not willing to work with us on it. So I think that I'm not sure what's going on. We've asked for depositions, and while Mr. Congdon has attempted to schedule a couple of those, we can't do those without the personnel files, Judge. So it's kind of the chicken and the egg issue here. So I think, unfortunately, we have been working diligently. We've been trying to work with the county, and we just don't have a very good report at this time. The only thing out of the many requests that we've received is the information regarding Sheriff Funk, and that's another issue that I believe Mr. Lansadell will address. So there's a lot there, sorry.
Not a problem. I'll hear from Mr. Lansadell and then from the county.
Thank you, Your Honor. First off, I'd like to apologize for the late notice of appearance. I got hired yesterday afternoon, late afternoon. I think there's really only three things that my client would like me to address with the court. The first one is that the sheriff's office felt compelled to hire outside counsel due to some of the conduct with the county attorney's office. And that conduct is concerning enough that I think it would be appropriate for this court to hold a hearing on it, as some of it directly impacts this court's writs and the county attorney's obligations under those writs, and what they have and have not done to ensure that their former client, the sheriff, was complying with them. As for getting the the policies to petitioner's counsel, we have no problem. We're happy to sit down and meet with them and provide everything that we can. I anticipate this should be a quick process with new counsel involved to get everything up to snuff and hopefully have my client released from the writ.
Was that all three things?
That was all three, Your Honor.
Just making sure. Okay. Mr. Congdon. And hold it. You are...
Okay.
Try again. In Mineral County to unmute. There. I believe we are unmuted.
This one's got a green light on it.
Go ahead, Mr. Congdon. I can hear you.
Okay, can you hear me now, Your Honor?
Yes, I can.
Okay. We have three separate items, Your Honor. First, in respect to what's been done and accomplished, a number of the things on Jordan Kilby's list, including who was notice sent to, that's been provided to them months ago. So which defendants, which parties, that was provided. Secondly, as subpoenas have been answered, we haven't forwarded whole personnel files, but we have sent parts that we got back from various people, including the information on Mr. Cashman. And I think I got some more recently, but we've been sending information to them in smaller stacks, not the whole file, as the subpoenas were answered from specific persons. And it's taken a lot more time than we thought because a number of companies or prior employers don't have a record of persons being employed, they say. So then we send back a social security number and ask again. And either they say, we still have no record, whatever. However, that's been provided for information. The Funk information from Lake County was sent. I have some other information they're looking for from some federal depositions in a federal case that I've not gotten all of yet. I have a law firm in Missoula looking for those that should find those regarding Sheriff Funk. Some issues in the past regarding either obstruction of justice or evidence, etc. That's the question. But those things are there. We also received Ellen Donahue's emails and finished going through a large bunch of them by yesterday. We have some to finish. We haven't decided yet. It's better to send those on a thumb drive to Lance the way we sent the Funk documents, or is it better to try to email them? But there's more than 6,000, I think. And we did not go back to just 21, which is what we originally said we'd do. But in looking through the emails, there's a record of things on at least one of the offers back through 20. So we went back through 2020, not just through 2021, because our original discussion was Lance Jasper knew from August of 2021 on, which was true. However, there was other information back to 2020. So we went back another 10 months earlier than we thought we were going to originally, because the information is there and we did not want to hide the ball or try to hide anything. There it goes. Thirdly, I'm unaware of what any question of retaliation would be from the county attorney's office, because we haven't said very much, except we were relatively disgusted that the sheriff went to Lance regarding hiring a deputy, which we said he could not hire because of an issue we thought may be Brady. And then the sheriff attempted to hire him, and then Mr. Jasper and the sheriff said, well, the sheriff called and contracted to do an investigation of that person by Dr. Stratford. And then the sheriff last Friday turns the bill in to the county commissioners for the commissioners to pay it for a person that hasn't been hired officially per the orders and the representations we made to the court. October 26th hearing and the September hearing, and I have both transcripts. However, what was interesting, Your Honor, is when the bill came from Mr. Stratford that the sheriff provided to the county, the bill was to Lance Jasper, Reed Bell and Jasper, Spur Street, Missoula. So Mr. Jasper did not have the sheriff hire Mr. Stratford. It appears to us that Lance did. So I sent the bill back to Lance this week and said, this is an interesting thing. How do you explain this? Because it's spending county money for somebody we did not hire per the order. I'm reminded by the court in your transcript when I read it again last week, both writs are against the office. They are not against the party. The writ of mandate regarding the county attorney was not against the county attorney. The writ of mandate regarding the issue of the sheriff was not against the sheriff. It was against the office, which is why the county is defending both of those. So having gotten those two questions there, it was difficult, though, to find the billing was not exactly concise. We then wrote Lance and asked for the information he'd reviewed in respect to Mr. Allard. And the response we got said he shredded all of it. And so while he does not have a copy, I also requested a copy of what Post has, and I have not received the Post copy either of that question. And I have also a request to Post out for information on 7 of our deputies, including Mr. Funk, Mr. Cashman, and 5 other deputies that are in the office that they have not forwarded back. But if they do not get it back to us by Wednesday, I will probably get a subpoena signed by yourself, Your Honor, and take it to Helena and get it served on Post and pick it up, because they should have had it back to us and they have not. In respect to the appearance of counsel for the sheriff, I have several concerns, Your Honor. Number one, the notice on the filing is a notice to Deb Jackson. She is not the attorney of record, the proceeding against the sheriff. I am. I was not noticed. The rules were not followed. Nobody seems to want to play fair. And I hate to be so old-fashioned, Your Honor, but the rules are serve the attorney of record, not serve somebody else. And if the goal is to change attorneys, but I think it's not, because the writ is against the office, not against the sheriff, and the note of his appearance says it's on behalf of the sheriff. How? The sheriff is not the party. The office was the party, but what it says in Title 37-61-403, to change attorneys in an action or special proceeding, it may be done upon consent of both the client and the attorney. And I was not talked to. I was not asked. The client, which is actually the county, was not talked to. and upon the order of the court upon the application of either attorney or client after notice from one to the other. So in terms of an appearance on behalf of a party, nobody complied with the basic statutory guidelines, and more than that, Your Honor, also there's an AG opinion regarding elected county officers, which includes the sheriff, is not required to obtain consent of the county attorney or in order to retain counsel in a suit brought by the county attorney. This action was not brought by the county attorney against the sheriff's office. It was brought by 153 private parties in a writ of mandamus by Mr. Jasper against the county sheriff and against the county attorney's offices, both of them. And that is an AG, Your Honor, which is 1985 AG 7, okay, which is 41 opinion of the AG number 34. So clearly, they didn't have to ask permission, but they clearly had to talk about it. And more than that, in a non-criminal action, which this is, in which a governmental entity employee, which a sheriff is also, is a party defendant. Now, I've said they are not a defendant, it's the office. But if you accept the intervention, the notice of appearance, which was improper, but if you accept that and say the sheriff is a party, read item D under part 6 of that statute, which is 29305. And it says, the employee failed or refused to cooperate reasonably in the defense of the case. Mr. Funk has tried to hire people behind the back of the county attorney and the commissioners, has submitted bills he incurred behind the back of the commissioners and the county attorney, and then did this appearance today without telling us. I see him every day in the building. If he's here just about, so does Deb. So frankly, if there were ever a claim to say the employee has failed miserably or refused more emphatically to cooperate in defense of the claim, this would be the matter. And I am not a happy camper about it, Your Honor, and I apologize. But part of the reason it's so hard to get all this stuff turned out fast, it's difficult to read 11,000 emails from Ellen Donahue's information, find out what's there, what was relevant, what had nothing to do with what was on a child case or something. It's difficult to go through this many cases. And also, the things we requested from Mr. Jasper last year, who are the people who violated rights, what officials violated the law? We've never gotten the list. We asked for a list of all parties defendant that his firm had between September last year and May, so we can make sure we had given notice to all of them for two reasons. One, I wanted to make sure that they had gotten the notice, Your Honor. And two, since Lance knew if they were not told of the Brady questions, they may assert an ineffective assistance of counsel claim. And I did not want the Montana Innocence Project to come back and beat on the county for prosecuting something where counsel had not been effective by disclosing the Brady issues. So I thought, why not confront the monkey on the front? Let's get that done too and clean the whole mess up. And I apologize that I am sicker than the devil, Your Honor, but I've got pneumonia again from a head injury 20 years ago, 19 years ago, and it's now turned into bronchitis and I sound like a toad. And I apologize, but I thought it was very important to be here, and I am. And if you have other questions, but we are certainly burning the night oil. I'm to work for this county 30 hours a week, Your Honor. I've done more than 40, 5 weeks in a row, trying to get this done and show his Deb. And we have also caught up on a whole myriad of other things that were not being done. So our backlog of felonies, our backlog of misdemeanors is in very, very fine shape. And so it's good that we haven't given up. We're also taking on some other projects that needed to be done on civil road disputes, et cetera. But it's frustrating when somebody in-house, you're trying to defend their office, keeps going behind you and kicking you, which is what I feel like Mr. Funk has done. He has not been straight with me. And there's a lot of things you can say about me, but anybody I've worked for in all the counties I've done this for will tell you, you may not like what Wally says, but I'm straight. And I do not like a feeling that he figures he's got to go behind and hide, because he didn't have to, and I don't know either lawyer. It also concerned me. I have a 2018 email from one of them in the Ellen Donahue stuff where the firm he worked for was Lance Jasper. So I'm like, how much insider trading is actually going on in the equation? And it stresses me greatly, Your Honor, and that's why. That's kind of our update, and we would rather try for an update, and if it's necessary for us to take the personnel files actually to Missoula, I can drop them off at Lance's office. I usually go there about 10 minutes of 8 in the morning because nobody answers the door till then, Your Honor. But when I took the thumb drive a couple of weeks ago, they didn't realize I dropped it off for 2 or 3 days because I dropped it off at 7:54. But if they want the personnel files to see, I don't have a problem with delivering them in an Apple box and saying, look, Deb does not want them to go because we're worried about what's being moved, et cetera. But my thought is, if you think that's really that necessary, it's doable to get those there.
Just from my perspective, Your Honor, those are personnel records that are the county's. I've gone through them, and I made a list of things, but I didn't make a copy. I didn't make an adequate list. If somebody takes something, puts something in, I wouldn't know it. Having those personnel records, we use them. Human Resources has to come up and get them from me. And so having them reviewed, I sort of declared them highly confidential. I have no objection to them reviewing them, but having copies made and sent out, these are actually employee files that I believe are somewhat constitutional rights, property rights in some respect for these employees. And that's why I don't think there's anything in them. I mean, I've subpoenaed every place that they've worked for them, but they can go ahead and review them. I just don't want them going outside the office.
My last note, Your Honor, because I said I had 3. The third note was this: if it's so important to the sheriff and his new attorney that wants to represent him when he's not a party, I would suggest they play by the rules and either do a notice of intention to intervene. If they wish to intervene as a party, then the suit for the writ is not just against the office, it's also against the sheriff. But if they wish to intervene, that's a motion they can make. I get proper notice, et cetera, and so does the county. And secondly, if they prefer to do it otherwise, by a request to participate as an amicus, which is a friend of the court and provide input, that is fine as well. And I do that a lot in federal cases. I don't do it much in state cases, but in a lot of federal cases, basically appearing as a friend of the court is not a bad thing, especially when there's briefs or discussions about what you're doing. So I don't think either one of those is a wrong course to take, but I think the course that they took flies in the face of your definition of what this was. And remember, that definition was based upon the fact that Mr. Toth was not served, and over the issue of personal jurisdiction, the point was made, this is not against the person. This is against the office. That's how we agreed. That's what we did in the record. And that's from the first hearing we had, Your Honor. So I am not changing the rules. I'm trying to not change any of the rules. I'm just trying to say, let's either play it right or let's not play it at all. Thank you, Your Honor.
Thank you, Mr. Congdon. I'll ask for responses from Ms. Kilby and Mr. Lansidel.
Thank you, Your Honor. I disagree with some of Mr. Congdon's characterizations. First, this is a writ against the sheriff. This is a writ against the county attorney. That's what the title says. The statute refers to the sheriff as the individual who has the hiring power and the responsibilities of appointing deputies. Second, with respect to the personal jurisdiction issue, that was waived by appearance, and we agreed on that at that first hearing. There was not a distinction between the office versus the person. Third, I understand Mr. Congdon needing to take more time, and that is certainly fine, but there are some things that I don't understand why they haven't been disclosed, like the policies and, again, the personnel files. The way that the protective order is written is that any files that we receive, Reed Bell and Jasper, will be shredded or returned at the end of our review. I don't know if it would make sense for the county to scan them, put them on a USB and send them to us. I don't think it makes sense for the actual physical original files to leave the courthouse. I would agree with Ms. Jackson on that. However, scanning them, sending them to us, and then having us return them or shred them makes sense. It is, with our schedules, it's just extremely difficult to set aside that time to sit at the Mineral County Attorney's Office for however many hours to review them. I believe Mr. Jasper's here now. He was not here earlier when I made the argument regarding retaliation. That was a conversation that was had with a trooper, with Sean Byzantine, and Ms. Jackson. And Mr. Jasper may want to speak more to that. I don't know if this is the appropriate venue for that, Judge, but it is important for the court to hear because, again, we are just trying to accomplish this goal of making sure that the county attorney's office and the sheriff's office are following the law. Mr. Jasper had appealed to the commissioners, the county commissioners, for another position for the county. And it's my understanding that Ms. Jackson said that she did not need that. But given Mr. Congdon's representation that he's working over his 30 hours, that they're working diligently, and this is just so much, I think that if Ms. Jackson is representing publicly that they don't need more people, then we should be getting our discovery requests in time. Further, Judge, I think Mr. Lansadell can speak to his internship with Mr. Jasper and how his representation came about. But we are welcoming that because it is our understanding that there, based on conversations with Mr. Lansadell, that there are things that the sheriff can actually be doing to further this process to get us what we need and get this taken care of, things that the county attorney's office is not doing. And then with respect to, well, I guess I'll just let Mr. Lansadell speak to the reasoning for that representation and his notice to the court or to the county attorney's office, because I did see that Mr. Congdon was served with that.
Mr. Lansadell.
Thank you, Your Honor. I don't think there's ever been a more clear demonstration on the record of a complete breakdown in the attorney-client relationship based on Mr. Congdon's comments about Sheriff Funk. Sort of demonstrates, one, why the sheriff felt he needed, and his office needed outside counsel. I think it also demonstrates the need for a hearing on some of the conduct that Mr. Congdon and Ms. Jackson have engaged in that the court needs to be made aware of. As for Mr. Congdon's objections to the notice, I filed that using the e-filing system, and it is Deb Jackson, who is the counsel of record on the e-filing system. I don't control who that goes to, but regardless, Mr. Congdon got a copy of my notice this morning via email. He got 2 emails with it, one to the judicial assistant to give your chambers a heads up that this would be filing in case it wasn't approved in time. And he also received a letter as well as the notice of appearance then and there. And if there are any concerns that the court has with defect in that notice, we're happy to rectify them. As for my relationship with Mr. Jasper, I was an associate attorney there for less than 2 years, from 2017 to 2019. So I, like most people in the legal community, we all know each other, and many of us have worked for one another at one point or another. And as for whether or not the sheriff is in the writ against the county attorney's office, or that applies to the county attorney's office, I was thinking about that this morning. In that action, the sheriff is not a party, so I couldn't file a notice of appearance in that one. But to the extent that the county attorney's conduct affects the sheriff's office in that action, it would be our intent to represent the sheriff in that action as well. And I'm not sure if I need to talk to the clerk to get a notice filed in that, or how procedurally we want to accomplish that, or if we even need to. Thank you.
Your Honor, could I be heard on one more issue?
One more.
So I just want to make it clear that, at our last hearing, Your Honor told Mr. Jasper not to have contact with Mr. Funk as part of this because, obviously of the ethical rule, he's represented by Mr. Congdon. Mr. Congdon brought up this issue of the bill from Dr. Stratford's office. And just so we're clear, about what happened, Mr. Funk contacted Mr. Jasper in an attempt to figure out his hiring process. And, Mr. Jasper represented last hearing that it was about the furtherance of this writ. Mr. Jasper has a very good relationship with Dr. Stratford. In fact, we represent a lot of law enforcement officers, and Dr. Stratford does evaluations for us all the time. And so that bill never should have been addressed to Mr. Jasper. It was just a means of connecting Dr. Stratford with the sheriff. And Mr. Jasper made that call, and that was a technical error. And so that's why his name is on that. He didn't order an evaluation for anyone. He wasn't involved in that other than making that that connection between the two. That's my understanding of that. So I can understand, when Mr. Congdon got that he was confused, because it did say Mr. Jasper on that, but that bill did not come to our office. It did through Mr. Congdon, but not through the sheriff's office, not through Dr. Stratford. And so any conversation between Mr. Jasper and Mr. Funk occurred prior to that hearing that we had, where that was disclosed by Mr. Jasper. The court informed him that he shall not do that going forward. He has not, regarding the writ, without representation of counsel. And so I just want to make that really clear. Just based on the allegations that Mr. Congdon has made with respect to Dr. Stratford as well.
Okay. So the court is going to make a few observations. One, the court is dismayed. The court is dismayed about how what the court believed were fairly straightforward writs have now descended into seemingly a free-for-all of name-calling, backbiting. I could think of a number of words, and this reflects poorly, I believe, on Mineral County. Mm-hmm. I believe it reflects poorly on this legal process as a whole.
Because you're dealing with Mineral County.
If there is retaliation, that is absolutely impermissible. And the court will schedule a hearing to deal with a variety of matters, because I feel like the parties are getting distracted from the objective of the writs. And it's become personal now. And to the extent that we can address, at least during these status conferences, the status of the writ's mandate, that's what the court would prefer these status conferences to be focused on. We can have additional hearings on other issues, but I'm keen to make sure we don't lose sight of the focus, which is to make certain that both the county attorney's office and the sheriff's office are properly complying with state and federal statutory and case law with regard to their duties to disclose information that reflects on the credibility and trustworthiness of law enforcement, which is held to an exceedingly high standard. And again, the purpose of the writs were to help the Mineral County come back into compliance. The court found, as a matter of the pleadings, that the county was out of compliance with those statutory and case law obligations. So, please, counsel, I urge you, nay, I beg of you, to keep your eye on the focus of those writs rather than becoming or letting your representation descend into personal attack. I want Mineral County to provide no later than Friday of next week the requested policies and personnel records. When I say personnel records, there is, I want the files to be copied completely or scanned completely and sent via a secure method to petitioner's office. That can be through the Montana file transfer system. It can be on an encrypted thumb drive. It can, if the county wishes to keep it all paper, that's their election, but it will be then paper that needs to be delivered to petitioner's counsel. Given the involvement of Mr. Lansidel, it may need, a copy may need to go as well to him. We'll talk about Mr. Lansidel in the sheriff's office here shortly. But there should be no further delay in getting the policy information, both pre-writ and now post-writ, in an electronic format to petitioner's law firm. That's an easy ask. And it's something that can be done very quickly and very easily, and I don't see a need for absolutely any delay with that. Personnel records, again, if there's a reasonable delay for the process of scanning, okay, but I want that, I want the both the sheriff's office and the county attorney's office to get it done, and I'm giving them a week to get those digitized and to petitioners' law firm. As for, now I want to transition to the involvement of the sheriff's office in the hiring of independent counsel. So as the court did say, it is the court's impression that whomever holds the office of the sheriff or the county attorney, this lawsuit has been denominated in the name of the office and not in the individual. Otherwise, Mr. Toth, former Sheriff Toth, would be listed in the pleadings, or current Sheriff Funk would be listed in the pleading. I have no problem if they wish to personally involve themselves, but then they are personally responsible for executing the writ of mandate. As to how independent counsel may be paid for, the court makes no comment on that. That is between the sheriff's office and the county commissioner's office, and I am not going to wade in on that issue. That is a matter for the folks in Mineral County to figure out. I'm not here to tell people who needs to pay what. I will point out that there is still an outstanding request for recovery of attorney's fees by petitioner's law firm. The court has taken that under advisement, and there will come a time when we have a hearing on whether petitioner's counsel does get reimbursed in whole or in part for the attorney's fees incurred in bringing the writs. It seems to me that the county has a keen interest in making certain that petitioner's counsel spends as little time as necessary on this particular case, because every hour incurred will add to a bill for which they will seek reimbursement. And I am well aware of Mineral County's limited resources, given a number of things that have occurred over the several decades, but even most recently, finances, like most small rural counties, are tight. And I would think, again, that all county officers would be working to make certain that this case can be dealt with quickly, can be dealt with inexpensively, not only for the county government, but frankly, the taxpayers of Mineral County. So I am encouraging all parties to work together to limit the amount of time and effort expended on this, so that in the end, if the court approves a bill and requires the reimbursement of petitioner's firm, again, which is still under advisement, that it is a bill that Mineral County can pay in a reasonable due course. Let me look through my notes to make certain that I have addressed everything. Once the information is provided to the petitioner's law firm, I think depositions ought to be scheduled fairly swiftly thereafter. I do recognize that petitioner's firm does need to have that information in hand in order to make a fruitful inquiry during deposition. So I endorse the plan of first the personnel records, second depositions. Mr. Congdon, if you need to issue subpoenas to get additional information, the court would endorse issuing those particular subpoenas.
I may bring you two, Your Honor. Surprisingly, one of them is to the Montana State Prison, which has not forwarded the records when Mr. Cashman was a guard there. And the other is to Post, which is the public officer's safety entity that trains policemen in Helena, which amazes me that they say all their information is public, but they have not forwarded the information we requested to us. So I may bring you both those next Tuesday or Wednesday and get a signature if we don't hear over the weekend in the mail by Monday or so. Those are the two biggest ones, because those are the two that I really need to get the rest of the information out.
Fair enough. In the interest of transparency, as you are bringing them to the court, once you have completed those, I would ask that you circulate a draft to Ms. Kilby and Mr. Lensadell. Again, I think that this process will be aided by full transparency between counsel, at least as to the actions that they're doing, and certainly any approach to the court is and involvement of the court should be done transparently with other counsel. And so certainly anything that is provided, said, or shared with the court needs to go to counsel contemporaneously with that sharing with the court.
Fine, Your Honor.
So the court is going to set two hearings. One will be a status conference, and I really do want that status conference focused keenly on the issue of progress on the writs. Court, may I ask if the parties have a conflict with 1 p.m. on Tuesday, April 18th for that update?
Is that a Wednesday?
That should be
The other
fine.
alternate would be 9 a.m. or 1 p.m. on April 18th.
I don't know if I have a trial.
That is fine with me, Your Honor. This is Mr. Congdon.
Have just a moment, Judge.
It'll be my partner that appears, but that's for our office, Your Honor.
Thank you.
Just looking at Mr. Jasper's schedule and mine. That works great, Your Honor. 1 o'clock.
So I will set a status conference on progress on the writs in both cases for 1 p.m. on Tuesday, April 18th. We only have an hour, so keep that in mind. Now, as to the issues that have arisen that are, I'm going to call them extra writ issues. Are parties available at 3 p.m. the following day, which is April 19th?
Judge, we have Judge Larson here for law and motion at 1:30. I'm not sure if
That is correct. Thank you for that reminder. The morning of April 21st.
Pardon?
You're unmuted.
Okay, you can unmute it, but that works for us, Your Honor.
That works for us as well, Judge.
It works for my partner, Your Honor. I won't be able to attend. If we could push it back 2 weeks, I could be here, but I want everyone to move their schedule around on account of me.
That might be a bit difficult, Mr. Lensadell. Let's set it for 9 a.m. on Friday, April 21st. And again, that will be to discuss the issues of retaliation, other issues, frankly, if the county has those issues. What I do want is at least 2 weeks prior. So on April 7th, I want full disclosure by each party what they plan to bring up on April 21st. And that should be both a listing of witnesses and exhibits and a list of issues. The issues do not have to be all-inclusive, but they better be sufficient to provide notice to the community. So I don't want any surprises or sandbagging at the April 21st hearing, is what I'm saying. Do we have anything else we need to address?
Your Honor, regarding the counsel for the sheriff, do we wish them to either one, try to file a change of attorney, or more importantly, intervene as a party or participate as an amicus? Because the way they did this does not comply with the statute based on what even you just said about it's against the office. But if Mr. Funk wishes to be a party, that should be an intervention.
So I think it would be premature for the court to weigh in on that issue. Mr. Bell now has understanding of at least the court's position, at least as to how this particular case is captioned. I will let Sheriff Funk, Mr. Lansadell, and the county determine how would be best to proceed forward and await for appropriate motions or other pleadings. But I think it's premature. I have not seen anything as far as briefing, and I'm not going to weigh in on that issue at this time.
Wow.
Thank you, Your Honor.
Thank you. I do need to move on to my next matter here in Missoula County. I appreciate everyone's attendance. You may log off at this time. We will transition automatically to Missoula County matter, which was supposed to be at 3, and I apologize to council for keeping them waiting. Thank you all, everyone.
Thank you for your time, Your Honor.
Thank you, Your Honor.
And now I will call the case State of Montana versus Matthew H.D. Fair. This is Missoula County cause number DC 21-264.
It's a shit show. A shit show. End of recording.